Welcome. My name is John Milburn. This is Laws 11057, Introduction to Law. This is Central Queensland University. We're into week 8 for term 3, 2016. Now we're into January of 2017. This week we're dealing with legal ethics and ethical behaviour. The textbook reading is chapter 13 of your text of the new lawyer, James and Field, as always. And we do have some other material that I will refer to throughout this evening. Firstly, the Australian Solicitors Conduct Rules, 2012. This is an excellent publication from the Queensland Law Society, and I'd commend that to you. It's not on the prescribed or even recommended reading, but it is worth having a look at because it deals with the rules and provides a commentary as well. In addition to that, we have the much shorter Barristers' Conduct Rules. Now that's 2011, amended as at August 2016, and we call it the 2011 Barristers' Rule. So that's the from the Bar Association of Queensland, that publication. Okay, now before we get into ethical behaviour and talking about ethical behaviour, I want to just review a few of the questions that we have had over the last few weeks and a little behind in terms of that. The comments that I wish to make in relation to exercise 7.2 from way back in week 4, which is a statutory interpretation exercise, I've posted. So that was, if you can recall, Jerry from the convenience store and the issue of being a shopkeeper but fulfilling a different role at the time of the commission of an alleged offence and the use of external materials to resolve the issue. So I've posted my response online. If you wish to make any comment about the response that you provided, please feel free to do so. Otherwise, we can read your material and your answers. And I thank everyone that has diligently posted material and encourage you to please continue to do that. All right, in a similar vein, from week 6, and I'm moving fast now, I know, to try and catch up. Exercise 9.2 was the issue to do with fighting for your client's rights. Once again, I've posted my thoughts in relation to the problem. If you wish to expand on what you've provided online, please feel free to do so. If not, we can read your responses, and once again, thank you very much for doing so. Okay, on to week 7, and you've noticed I've missed a week here, but week 7, exercise 12.4, which is treating all litigants equally, and the issue of representation. Now, can someone tell me the lead case in relation to the issue of whether there is a right to be legally represented in a court trial, even a criminal trial? You can unmute.
There is.
Yes, what's that, Grace? What's the case?
There is a right to have access to legal representation.
Well, I'm not sure that the High Court agrees with that. We often see...
Isn't that what, like, legal aid and that?
Well, legal aid's available, but it's not readily available in all circumstances. There are pretty strict means tests. So can anyone tell me the case that the High Court dealt with? I'll give you a hint. It was 1992. Thanks, Grace. Yes, Alan?
John, is that the Dietrich case?
That's the one.
Is that the Dietrich case?
That's it. Yep, Dietrich. And that was the case, you might recall, where a person was charged with serious crimes and ultimately went to the High Court, essentially demanding that justice would require him to have a lawyer represent him. The High Court disagreed and said that legal representation is not a right that is available in all circumstances. So you see our system is a little different to the American system in that regard. Even though the charges were criminal, serious in nature, it was held not to be an abusive process for him to face the judge and the jury without legal representation. All right, so you can see my response, which I've posted to exercise 12.4, which is part of week 7. All right, so let's move on. Let's move back now to week 5. This was chapter 8 of your reading. You might recall this was all about legal logic, week 5. And I've invited you to have a look at your own responses to 8.2, but which is the 9 practical examples of the 9 forms of faulty reasoning. All right, so I'm just going to go through the 9 examples of faulty reasoning, and they are accident or sweeping generalization. So you might make a note of this because I'm going to ask you some quiz questions in a minute. So the first one was accident or sweeping generalization. Try to remember what that's all about. And if you're watching this and you're not live, watching the recorded session, please do the same thing. Second one is reverse accident, which is hasty generalization. The third is attacking the person. The fourth is appeal to authority. The fifth is appeal to majority. The sixth is affirming the consequent. The seventh is straw man argument. That's one word, straw man. Number 8 is correlation and causation. And these are all in your textbook. And number 9 is bias. Now, let's see how we go with this exercise. Don't worry, I won't labour over this too long. But what I'm going to do is give you one of my 9 answers, and you can tell me which of the forms of faulty reasoning I am attempting to describe through the practical example that I give. Does that make sense? So we're doing this in reverse. So I'm giving you the answer and you're telling me the question. It's Jeopardy, isn't it? All right, so what is this an example of when it comes to faulty reasoning? Listen carefully. Every dog I saw on the beach this afternoon had long hair. Therefore, all dogs have long hair.
Is that appeal to majority?
No, don't think so.
Sweeping generalization? Sweeping generalization or accident?
Yeah. And one of the problems with these things is that you can categorize them differently. It's not how I categorized it, but I think that that's close.
It could be attacking the person or something as well.
Yeah.
Or
No,
attacking the dog.
I didn't go with that either. So that's 1, 2, 3 down. We've
I
got
agree with Wendy. I think it's
Wendy. Yeah.
yeah. I think it's appeal to the majority.
Okay. That's very strong support you've got there, Wendy. We have Sharon says sweeping. Louise says accident, reverse. And that's the one I thought it was. So I'm going to go with that answer, reverse accident or hasty generalization. But it was poor logic and there are different ways that you can categorize it. All right, I'll give you 2 more, okay? So we're ready on our buzzers. Listen carefully. Jones was watching the news. Jones was not watching Channel 7 News. Therefore, Jones was watching Channel 9 News.
Would that be correlation?
Correlation, number 8. I didn't have it down as correlation, Rebecca.
Is that
Not to say I'm
affirming
wrong.
the consequent?
Wendy says affirming the consequent. Alan will probably come in and agree with that, Wendy, in a minute. I agree with that. That's what I had it down as. So thank you, Wendy. All right. One more. Okay. Listen carefully. A person growing up in a country town may have had a carefree upbringing and therefore may assume that all children brought up in a country town have had a carefree upbringing.
Sweeping generalization.
You'd think so, wouldn't you? But I didn't put it down as that.
I'm
Alan
going to
agreed
go
with you. Alan
correlation.
agreed with you. Yes, Wendy?
Correlation?
Again, you'd think so, but I didn't. Sharon agreed with you, Wendy. Went with correlation. Any other thoughts?
Well, what about appeal to majority?
Arguable, but not what I put down. Sorry.
Straw man?
What's that,
Straw
sorry?
man? Straw man?
Yeah, you could argue it's straw man, but I didn't. So we're getting down to a few now.
Maybe appeal to authority.
Grace says appeal to authority, and Louise and Simon say bias. Thanks, Grace. I'm going to go with Louise and Simon. I had it down as bias. However, what I've just said is not necessarily right. They're just my views, and they're just some of the examples that I came up with in relation to faulty reasoning. I guess the main
John,
point...
a question.
Yes, Alan?
Question. Can you tell us why you thought it was biased and not sweeping generalisation?
Yeah, that's a really good question. I suggested it was bias because it shows that there is a predetermined attitude, which I guess is a hallmark of bias. But you could really argue the sweeping or general hasty generalisation just as easily and just as convincingly. One of the reasons I wanted to go through that exercise is to say that when we come to law, and it's a theme that I've had throughout, there's not necessarily a right or wrong answer. And just because I've said it, that's what my view is, doesn't necessarily mean it's right at all. And we see that for those of you doing statutory interpretation repeatedly, where we have a decision of a trial judge overturned by the full court and then overturned again by the High Court, particularly in majority type decisions. Okay, so thank you for participating in that little exercise, and thank you for providing your thoughts. Let's talk about ethical behaviour now. We'll move on to the text and chapter 13. So in the text, you've got reading from pages 435 through to 455. There's a lot of that which is for interest and context. I'm mostly concerned about the ethical obligations in terms of court and client and community. There's some excellent ethics quotes that you can find on the Queensland Law Society Ethics Centre website, and I'd commend that to you. And as we speak, I'm going to see if I can call that up onto a screen, onto my second screen. Has anyone had a look at the Queensland Law Society Ethics website? The Queensland Law Society Ethics website is an excellent resource, and for those of you that are keen observers of the way in which I do things, you probably noticed that as I said that, I was recording it into my voice recognition software so that it would bring up the page on the screen. I do that
I have a
sometimes.
printout. Oh, sorry. I have a printout of this, but I haven't read it yet.
Oh, okay. So that's the one,
I think
Grace? That's the one.
Yeah. Yeah. Okay, cool.
I'm just
Thanks.
going to now share the screen. We'll see if we can do this successfully. And unfortunately, as was the case last week, I'm getting a sign saying that I'm getting a poor internet connection. So bear with me if it cuts out. So here we have the Queensland Law Society page, and the Knowledge Centre is particularly useful. And you'll see down the bottom that there are some ethics news. You often see ethics quotes over here, and we see ethics resources. We have the ethics rulings and guidance statements. Those guidance statements over here on the bottom left-hand side are an excellent resource in terms of providing you with a brief statement as to ethical rulings. And the Ethics Centre is excellent as well. So you'll see here that there's a reference to the Ethics Centre over on the right-hand side. So just when you have an opportunity, go and have a look at the Queensland Law Society website, because it does provide you with some wonderful resources in terms of a whole range of different things. Okay, so here we have a link to the Ethics Centre, and Stafford Shepherd is an excellent practitioner who is the person responsible primarily for the Ethics Centre. Okay, so that's got some really good material for you to consider if you have any ethical questions that you wish to consider. So oftentimes in exams, you'll see ethical type questions, not that we have an invigilated exam on this occasion. All right, the other thing that I want to remind you about is the excellent material provided by Judge Morzone, which is available to you on the website. And that's the Zoom session that I conducted with His Honour a little while ago. Sorry, I'm scrolling down quickly, but I'm just trying to locate that session which deals with Judge Morzone. So here we have Judge Morzone's paper and the PowerPoint material, and we have his the Zoom session there, I believe, as well. So if you do have an opportunity, please look at those materials, because they are excellent. And I'll make a note to myself to provide you with the link to the Zoom session for Judge Morzone, because I can't see it there immediately. So I will provide that to you. Speaking of publications, I've already mentioned the Australian Solicitors Conduct Rules. Now, that's here in part, but you don't have the annotated version because that's a paid publication. But you do have some materials, and we've downloaded some of those materials from the Queensland Ethics Centre for your consideration. The other thing that you might want to consider is the website for the Legal Services Commissioner, which also provides some very valuable information in relation to ethical issues. So typically, if someone wishes to make a complaint about the conduct of a lawyer, whether that's a solicitor or a barrister, they would go to the Legal Services Commissioner, and the Commissioner is Mr. Paul Clausen, and he was formerly the Attorney General of Queensland some time ago. So there we have, in addition to other materials, regulatory guides, publications. There's a link there to some fact sheets, forms, speeches and papers. So some valuable information in relation to ethics. So I'd ask you to please consider those things. All right, I'm just going to stop the share now. and come back. Are there any questions so far in relation to what we've discussed or some of those resources that I've mentioned? Yes, Rebecca?
In relation to the Legal Services Commission, is that only in Queensland? It's not available in other states, is it?
It's certainly only the Queensland Commission that I've spoken to you about. To be honest, I don't know about other states. It may well be that other states are still regulated through the respective law societies. So by way of history, the Legal Services Commission came into effect in 2007, I recall, with the advent of the Legal Profession Act. And prior to that date, the issue of regulating the affairs of solicitors and the conduct of solicitors was done through the Queensland Law Society, and also for barristers through the Bar Association. But now we have the independence of the Legal Services Commissioner and the Legal Services Commission in terms of those issues. Now, can anyone tell me? Yeah.
Sorry, just
Yes,
one more
Rebecca.
thing. For lawyers who want to go into a particular firm, for instance, can they contact the Legal Services Commission and ask if there's been any reported ethical behaviour by,
Yeah, well, you could certainly try. They may or may not provide a response. The answer is I don't know. However, that's a good question because it does lead neatly into what I was about to say next. And that is, where would you find information about complaints made by solicitors in the public forum? In other words, where are these cases about solicitors and barristers' misconduct heard? Does anyone know? All right, so just to follow on from what Rebecca mentioned, if there is a complaint about a lawyer, we now know that you would go to the Legal Services Commission. The Legal Services Commission may make a decision. What if you wish to appeal that decision? Where would you go? No? Let's share the screen and I'll go back to the Queensland Law Society website, and you'll see there in the middle a thing called Discipline Updates, and you'll see there that the Legal Services Commissioner will be involved in litigation against the practitioner, and there we have the names of 1, 2, 3, 4, 5 lawyers who have been through this litigation process, and it's actually the Queensland Civil and Administrative Tribunal. So here on the 15th of December, we have a decision or a case summary in relation to a matter of the LSC against Reeve. I'll show you this for a couple of reasons. The first is that, well, a few reasons. The first is to reinforce the value of going to the Queensland Law Society site. The Bar Association has good material as well, but the Law Society's material is excellent on ethics. The second is to show you that that's where you can access the cost guide that we've referred to. The third is that this is an example of a case summary. So it was actually written by a work experience student in conjunction with 2 ethics clerks, but approved by Stafford Shepherd, the director of the Ethics Centre. So it'll give you an idea of how other people write their case summary, so that might be useful as well. And to show you that it goes through the Queensland Civil and Administrative Tribunal, and I'm sure you know that I'm a member of that tribunal. So I'm just trying to link to that case. You'll see that you can link to the QCAT cases through the Supreme Court Library. There is the case summary and the actual decision there by Justice Thomas, the President of the Tribunal, assisted by 2 legal panel, lay panel members in that case. All right, so I'll just stop the share there. So any questions about the issue of legal discipline, where you go to make a complaint, where complaints are dealt with at first instance and where they're dealt with ultimately. And I should say that if someone wishes to appeal the decision of the tribunal, then they would go to the Supreme Court in order to do that. Okay, all good? All right. Let's just talk about professional ethics generally. So for a solicitor, in terms of ethical obligations, where would we look? What's the primary document that guides the ethical rules for the conduct of a solicitor's practice? Can anyone help me with that? I'll give you a hint. We've mentioned the legislation, but the rules are there. Okay, so the Australian Solicitors Conduct Rules 2012. That was an attempt for nationalising the rules. Queensland was very quick to adopt those rules in 2012. Now, the fundamental rules of practice, the duties of a solicitor, are contained in rules 3, 4, 5 and 6. Now, I think Grace has a copy of these rules. Does everyone else have a copy, or does anyone else have a copy? Very good. Rebecca, Tegan, not sure if I can see any others. Wendy, Alan. Right, Sharon. So lots, that's good. All right. So if you've got a copy, please have a look at rules 3, 4, 5 and 6, because to me, they provide the fundamental basis upon which a solicitor must act. And the first one that you need to consider is the paramount duty to the court and the administration of justice. Now, to my mind, that's probably different to what law students coming into study law would think, and I think almost certainly different to what members of the public would think is the paramount duty of a solicitor. Now, why do I say that? Yes, Alan?
John, is it because there's a tension between being an advocate for a client, but also being devoted to the principles of the law?
Exactly. I think, and correct me if I'm wrong, because it's only a view that I have, but my view is that most people would think that the paramount duty that a solicitor has is to the client. Cynically, they might think that the paramount duty that the solicitor has is to him or herself. But beyond that, the duty is to the client, most people would think. But it's actually to the court and to the administration of justice. That responsibility, that duty overrides the duty to the client. And Louise has kindly put a link to the conduct rules. Thank you. If someone wants to put that on UCrew, that would be excellent. So thank you, Louise. All right. That's rule 3, the paramount duty. If you want to read a case or look at a decision there, consider the comments of Lord Reid in Rondell against Worsley, which is 1968, 1 Appeal Court, that's AC, 191, and at 227, Lord Reid said, every counsel has a duty to the client to fearlessly raise every issue, advance every argument, and ask every question, however distasteful, which he thinks will help his client's case. However, as an officer of the court concerned in the administration of justice, he or she has an overriding duty to the court, to the standards of his or her profession and to the public, which may and often does lead to a conflict with his client's wishes and with what the client thinks are his personal interests. So we have not only Rule 3, which is very clear, but we have the judicial comment of Lord Reid in Rondell and Worsley in support of that principle. Other than that, the solicitor must act in the best interest of the client, must act honestly, with courtesy, and must act competently. Now, is that fair, that it's an ethical duty of a solicitor to act with competence? Is that fair? What does it mean? Any thoughts?
Well, to be competent is to sort of be aware of what you're doing, isn't it?
It is, yes. So competence is being aware of what to do and doing it to a certain standard. Now, if you read Rule 4, it suggests to me that if you're not competent, you are acting unethically. Is that appropriate? Is that fair?
It would be
I
unfair.
think it also, oh, sorry.
Oh, sorry, yes, Dakota?
I think it'd be unfair for your client if you weren't showing confidence and that you knew what you were doing and you went into a courtroom and the other side was just hitting you with everything and you had nothing and you were not showing confidence in anything you were saying. As a client, I wouldn't want a solicitor who looked like that in front of everybody.
Okay, thanks, Dakota. Shireen and Louise agree. Tegan, do you wish to add something?
I was basically going to say the exact same thing. 4.1.1 says act in the best interest of your client. So I don't think you should take on a case if you're not competent in that case. It's definitely not in the best interest of the client.
No. Why I raise the issue is that I would think it's not readily apparent that a lack of competence equates to unethical behaviour. If you have, let's say, a plumber do some work badly, do you regard that as engaging a plumber who's incompetent or engaging a plumber who is both incompetent and unethical? I think the answer is probably not. But in law, we have a special duty. And the reason why incompetence in law can also equate to unethical behaviour is we have an overriding obligation and duty to the court and the administration of justice. So if we purport to know what we're talking about in standing before a court or engaging in legal practice, we need to do so competently. Otherwise, potentially, we're doing so unethically as well. And Shireen raises a very good point, and that is, who decides who is or is not competent? And the question is, how does one decide whether a solicitor is or is not competent? Does anyone wish to add any comments or thoughts to that?
Could it possibly be the client or even the judge by the way that they behave and the way that they represent the client?
Yep. So when you say the judge, what court are we talking about, or what jurisdiction?
Oh, sorry, I just took it to say that they were already in the courts. So,
Oh, okay.
yeah. Yeah,
When
yeah.
appearing in front of a court. So the court
Yes.
summarily basically say you're acting unethically because you're incompetent. Look, that can happen. Magistrates and judges can refer practitioners directly to the Legal Services Commission. Shireen, do you wish to add something?
Yes, I was wondering in relation to that, is it that if someone makes a complaint to the, we mentioned before, I can't remember the name for it, if someone makes a complaint about you, that's when it's decided whether you're competent or not?
Yes, so it may be that the arbiter of the question as to whether you're competent or not is the LSC or QCAT.
LSC, that's it, yes. Oh, okay, yeah, thank you.
All right, thank you. You know what, Alan?
I think we probably have to make up our own minds if we're competent or not, because even though we might think we are all the time, there might be occasions when we become incompetent for whatever reason, whether it's illness or some sort of ill disposition. And I think it is unethical to not be competent when you're representing a client, because you're basically putting that client at a disadvantage.
Yes. Thank you, Alan. So really appreciate the discussions there. On the other hand, as lawyers, we must be brave. One must be prepared to take on a fight and argue a position. And sometimes when you do that, you run the risk that it may all come unstuck and you may feel incompetent. But rest assured that if you've put forward a good argument, you've done your research, then even though you may be relatively inexperienced, you'll still not be incompetent or unethical. So I still want you to be brave and don't be scared off by those considerations. I hope that makes sense. All right, then consider Rule 5 and Rule 6 of the Australian Solicitors Conduct Rules. You'll see that you will fulfill your obligations primarily if you are diligent, you're honest, and you engage in conduct reputably. At all the time, being mindful of the fact that your paramount duty is to the court. Now, I want to have you consider Rule 6, which is undertakings. Can someone tell me what a lawyer's undertaking is and what it means to breach a lawyer's undertaking?
Could it be like, because in here it says a promise, could it be something within a client agreement? If you've set a certain amount, or you said, I won't charge for anything that's legal aided, or something to do with that?
Yeah, so Dakota says it's perhaps in relation to a client agreement or promise. It's a little more specific than that. An undertaking is a very specific type of promise. So Louise says it's a promise to do something or not to do something. It must be honoured and we must ensure it's delivered in a timely and effective manner. That's good. Linda says an undertaking is to confirm something will be done in a specific time frame. Okay, I prepared a Zoom video on this. I think it's in the resources. I've been doing this for a while, so I prepare these things and then sometimes I'm not sure I load them on. I'll make sure that I load it on, and it's a video in relation to Rule 6 and the importance of an undertaking, what it means and what it means to ignore it. Do so at your peril. I will just say this, that an undertaking is a very specific promise by a lawyer which is enforceable through breach of ethical obligations. It doesn't, if a lawyer says, I undertake to pay $100,000 to someone on this day, and they don't, there's no excuses, in the sense that, oh, well, look, the reason I didn't pay the money is that the client promised to pay the money and now hasn't, so I'm sorry I can't fulfill that undertaking. The court will say, so sad, too bad, or too bad, so sad, whatever the term is. You've got an obligation. So if you give an unconditional undertaking as a lawyer to do something, there are no ifs or buts or maybes or excuses. It's got to be done. Otherwise, it will be an issue that is something that can be enforced. The contrast to that is that a lawyer may undertake on behalf of a client to do something. By adding in that little phrase, I undertake on behalf of my client to pay $100,000 on Friday, changes the nature of the undertaking completely. So it's important that in practice, you consider those words on behalf of a client, both in terms of the person giving an undertaking or the person receiving the undertaking. All right, so please keep that in mind and have a look at that, that video. All right, I will just move on because I'm running out of time again. On page 460 of your text, you'll see some comments in relation to a number of specific things. One that I think we should talk about is the client that is guilty but still wants to go to trial. Can lawyers ethically do that? And if so, on what basis can the lawyer do that? I'm guilty, but I want to plead not guilty and I want you to represent me. Yes, Grace?
They can't give any false evidence towards supporting them being not guilty.
Correct. Very good. So,
but yeah, they can still take it on and do it.
So Grace says yes, we can still do it. Shireen says try for a lesser charge. Yes, try and negotiate. What's that? Sorry. Yes, Rebecca.
Sorry. Yeah, John. Is it also where perhaps the client has provided their instructions and it's conflicting with your obligations?
Yes. You've got to be careful that you don't act contrary to that paramount consideration. But the reason that why lawyers can go to trial representing a client who pleads not guilty, even though the lawyer is aware that the client is guilty, is that we must remember the basis of our criminal justice system is that a person is entitled to say nothing at all in defending a charge, and it is for the prosecutor to make out the charge. So from a technical point of view, the term that we use in those circumstances is that our client is asking us to represent them to put the Crown to proof. In other words, not guilty, let's see if the Crown can prove it, because that's what they have to do. We can't put up an affirmative, we can't put up a positive case in the alternative, so we can't lead evidence of a false alibi, or we can't lead any evidence at all that is incorrect. We can't make any statement that is misleading or deceptive to the court, but we are nevertheless perfectly entitled to see if they can prove it. And if they can't prove it, then we're not duty bound to say, all right, well, I'm guilty, even though you don't have the evidence. I'll put my hand up because I'm actually guilty. Do you understand the difference what I'm trying to make there? The distinction that I'm trying to make? Okay. All right. So we have some exercises this week. Exercises 13.4 and 13.5. I had a look on the website and I wasn't happy with the number of responses. So I want to talk about those next week. If you have provided a response to those questions, thank you very much. If you haven't, please do so and be prepared to discuss those questions in tutorial next week. So that's 13.4 and 13.5. Next week is feedback week, and it's also brainstorming week. What's brainstorming? Well, when you consider the ethical duties that we've discussed tonight, one of the duties is to consider, some of the duties are to consider different ways of resolving an issue. Have a look at what Parker and Evans have to say on page 467. They say you must take a holistic view of your client and their problems. Your relationship with your client is more likely to be participatory, emphasising a dialogue rather than a simple exchange of instructions and advice. And you must look for non-adversarial ways to resolve disputes. So next week's exercise, brainstorming, is going to see if we can put into practice those issues which are referred to by Parker and Evans on page 467. So please read that. I'll try and create a scenario, put it on the website so we can discuss different ways of resolving disputes. So next week, we're going to go into our toolbox and we'll see if we can find different ways of resolving a dispute for a client in a creative manner. We'll also discuss those questions that I mentioned before. And feedback week is soon you'll see a big red button on the Moodle site, which is your invitation to provide feedback about the course. And I encourage you to provide that feedback. It's valuable to the uni and it's valuable to me. All right, are there any questions about what we've discussed so far tonight? All good? Okay. All right, well, I might stop the recording now. And for those of you joining me for statutory interpretation, I'll see you in just over 10 minutes. But thanks for your participation tonight, and we'll see you next week. All the best. Bye.